Okay, it looks like everybody has their notes together and mic set. So we will get started with our 9 o'clock panel. Um, our first panel is, of course, for my own division, the Division of Corporation Finance. If it's your favorite, I would completely understand. Um, we are honored to be joined by former commissioners Elad Roisman and Kathleen Casey as commentators for our panel. So it should certainly be a lively discussion. Elad Roisman is a partner in Cravath's corporate department and a former commissioner and acting chairman of the SEC. Mr. Roisman joined the SEC after serving as chief counsel for the U.S. Senate on banking, housing, and urban affairs. Prior to his work at the U.S. Senate, he served as counsel to SEC Commissioner Daniel M. Gallagher, chief counsel at NYSE Euronext, and as a corporate lawyer in private practice in New York. Kathleen Casey is a senior advisor with Potomac Global Partners. She has more than 2 decades of experience in senior government, regulatory, and legal policy roles. She completed a 5-year term as a commissioner with the U.S. Securities and Exchange Commission in August 2011. And during her tenure, Ms. Casey acted as the SEC's principal representative in various international fora. Prior to being appointed commissioner, Ms. Casey served in various legal and policy roles in the United States Senate. Before starting our panel, I ask that you please consider the comments of this session's panelists. Now, I am pleased to be participating in this panel along with the individuals that you see here from Corporation Finance. We have Sebastian Gomez-Ibero. He is the Acting Deputy Director for Legal and Regulatory Policy, as well as an Associate Director for the Disclosure Review Program. We have Michael Seaman, who is our Chief Counsel, Ted Yu, who is Associate Director for the Specialized Policy and Disclosure Offices in CorpFin, and Luna Bloom, Acting Associate Director for the Offices of Rulemaking and Small Business Policy. So thank you all for joining me today. Okay. Before I get into the substance, I want to bring up one major takeaway from my time as acting director. After 23 years in the division, I already knew it was full of incredibly dedicated, talented public servants. But from this perspective, as an acting director, I have managed to become even more impressed with the depth of knowledge and commitment of the staff. I know many staff are listening today, and I just want you to know that I appreciate you and thank you for your professionalism and your dedication to SEC's mission during this time of transition. I am really proud to say that, we have certainly not been short on substance during this transition period during my tenure. So far, we have issued 21 new compliance and disclosure interpretations, revised 40, withdrawn 17 outdated interpretations. We've issued over 350 no-action responses, mostly on shareholder proposals, but covering some other impactful topics as well. We put out 1 new staff's legal bulletin, Lab 14M, which has already received lots of attention, which you'll hear about today. We revised and expanded our draft registration statement policy. We issued 4 staff statements on crypto asset matters, and this doesn't even cover some of the items that we did last week. If you look at the CorpFin senior officers on this panel today, much of the activity that I just referenced is through their thoughtful consideration of feedback from various stakeholders, consideration of that feedback with observations that we are seeing also from the staff perspective, excellent collaboration and leadership. So I really want to thank those senior officers on the panel with me today. So with that, I'll let my colleagues on this panel on CorpFin workshop later today also weigh in on some of the specifics. But I think you'll agree that the division has been fairly busy, and I imagine that means that we've been keeping you busy as well. Particularly in light of all of the new guidance, I do want to emphasize that CorpFin continues to welcome questions from market participants. As you can see from all of the activity that we have had in the last few months, we gain valuable perspectives from all of you, and we really count on you to share what's on your minds and the minds of companies and clients. I do have a few recommendations that might be helpful if you are interested in reaching out to the staff. If possible, please direct your questions to a specific office so we can get a response back to you more quickly. So, for example, if you're calling about a filing review in the disclosure program, you can reach out to the reviewer's office directly and elevate any questions that you may have. For other questions, our specialized policy offices also have phone numbers that are listed on our CourtFin webpage. And that webpage also has a request for interpretive advice that you can submit to the respective office. As a matter of policy, we generally don't answer hypothetical questions, but if you have something in process, please call us as early as you can if you think that you have a novel or especially complex question. The staff gets lots of external communication, so we want to get you in the queue as quickly as possible. And I think it's interesting, Alad and I were talking in the room in the speaker ready room before we got started. And I think this notion of kind of when to come talk to the staff if you have a hypothetical and when do you get to the point that you're ready to bring it to the staff. Are there some challenges that you have seen from your perspective, Alad, that might help us in kind of figuring out the best way to guide companies on when to come talk to us? And I'm going to put you on the spot.
Sure. Well, thank you very much for PLI for having me. Thank you for the kind introduction, Cicely. I think we're in sort of an interesting time, and I think people have been very excited. And I want to thank everyone on this at this table for your leadership and work so far this year. I think everyone's been very excited about the guidance that's come out, the approachability of everybody. I think what's happening though is, people are very excited. And when they're very excited, they're trying to figure out how can we, think creatively to get, capital back into the system. And as a result, there's obviously the traditional, registered offerings and IPOs, but there's also some new sort of innovative thinking in terms of transactions and how to make these things work. And some of the questions we often get is, when do we need to go to the staff? And how do we sort of, structure this to make it successful? And so there's a little bit of a difficulty for folks when they're sort of brainstorming to say, well, I really want to sort of brainstorm with the staff on how to do this. And, understanding that you are not outside counsel to these issuers, what people are trying to figure out is there's got to be something in the middle before, we have to put paper in front of the commissioners or I'd say in front of the staff. At what point in time are people thinking, can they come to you and say, here's what we propose. We think these are the things you're going to care about. This is how we're addressing it. But there's a little bit of a no man's land of, understanding when to approach and, what sort of guidance you'll be providing. I think historically people have found that they'll say, well, this is all well and good. Thanks for the background. Put it in right. So, I understand it's a little bit of an unfair question for you, but what are you expecting when folks come to you in terms of granularity and, considerations? If they're, these are live transactions that are going on in order to sort of expedite the review process and get a little bit more clarity.
Yeah, I think that's something that we struggle with as well, right? Because we do want to be helpful. I think one things when I mentioned, it's hard for us to do things in the hypothetical. I think there's probably some things that would be helpful to work through with your gatekeepers, your outside counsel, your accountants on matters, just to bounce it off of them. And so I think maybe having some questions that are targeted and really help us understand kind of what is the concern and where do you maybe need relief? Where are you trying to figure out, just to make sure we understand which office that you might need to get support from. But I think one of the things is that we aren't able to kind of help you build your transaction, right? And so I think some of the tension points and maybe some of those questions need to be thought about in advance before coming, understanding that that's probably going to change, right? So we might need to have more than one conversation. We'll have a conversation. maybe give a couple of questions that might help target where you guys might want to go. You might want to talk a little bit amongst yourselves and then come back and have another more fulsome conversation. So I would say let's try to treat it as a dialogue. I think, there will be a time where it will be helpful for us to get something in writing just because oftentimes when we are working together, there's more than one office potentially that could be working through something. And so for us to make sure we have a solid understanding of the facts, generally when you have something in writing, that helps to facilitate that. So I would say, that's definitely a delicate balance between kind of the hypothetical, but also early stages. But we do want to make sure that if there's some complicated transactions that you're thinking about, if we can figure out a way to work together to get it brought in early, so that way we can think about the timing and hopefully work with your timing as much as possible. And I think that's probably going to be one of those things that is going to be very specific, but if you have some questions, please come talk to us and then we can think about the next steps that we might want to take to get the transaction moving forward. I think one of the other areas that you'll also see where staff is very interested in getting feedback, and we remember there's also the no action request process. If you're interested in that, you can go through our website and division staff will work with you to resolve your questions through that format as well. So in general, for opportunities to share your views, you're going to also hear from others on the panels about shareholder proposals for stakeholders for that. We have some interesting options from that perspective, as well as an executive compensation roundtable that we will be talking about a little bit later on this morning. So I think we're trying to be innovative in ways that we can solicit feedback from all to make sure that we can continue to be responsive to questions that people may have. And with that, I will turn it over to my colleagues. Sebastian, I think you're up first.
Thank you, Cicely, and good morning, all. So glad that you're here. I'm going to continue with this theme of outreach and engagement that Cicely has been mentioning. As Cicely mentioned, since January, the staff has been very active at engaging with market participants. And in fact, I know back to the stats that Cicely mentioned about all of the accomplishments over the last few months. And those accomplishments are a direct result of engagement with market participants like you all. So we're very much open for business and looking forward to hear from you. As part of that engagement, this past Friday, the SEC announced that it's going to hold a roundtable on executive compensation disclosure requirements. Mark your calendars. That roundtable is going to be on Thursday, June 26th. It's going to be in person at SEC headquarters, or you can watch the webcast live on sec.gov. As you probably saw in connection with the announcement, Chairman Atkins issued a statement with questions for the staff to consider and encourage members of the public who are also interested in this topic to provide their views on these questions, either in advance or after the roundtable. So I'm going to take a few minutes today to just provide a little summary of those questions. And to me, they fall into one of several categories. First of all, there's questions about how decisions are made within the company with respect to executive compensation. Second, there's questions about how investors are using executive compensation information and whether, despite the complexity and the length of that information, those investors can actually identify the material information they need, and whether the rules could be revised to return to a simpler presentation and focus for those investors. Third, there's questions about how executive compensation disclosure has changed over the last 20 plus years. As you can tell by anyone looking at a proxy statement, those disclosures have gotten longer, and there's quite a bit of complexity in those disclosures. Fourth and last, there's questions about some of the hot topics that we've been hearing about as a result of our engagement. including disclosure about pay versus performance, clawbacks, and perks. So, if you have thoughts about these topics, how can you engage with us? To facilitate the input on these topics and those questions highlighted by the chairman, the SEC has created a comment file for the public to submit that feedback. If you look at either the press release that was issued last Friday, or if you look at the chairman's statement, you will see that there's a link in there if you want to submit those directly on our webpage, or an email address if you would like to emails with those with that feedback. What I thought I would do for the next few minutes is share a little bit about the feedback that we've been receiving in connection with other topics. Luna and I are going to tag team here and give you a little bit of a flavor of what that feedback has covered. No surprise to many here, the SEC's exempt offering framework continues to be a hot topic. The accredited investor definition, if you don't know already, is central to many of the exemptions from registration, and the inability to qualify as an accredited investor currently prevents many investors from having access to private deals. Over the last few months, we continue to hear suggestions about possible ways to expand who qualifies as an accredited investor and how to give investors more access to private companies. We also continue to get questions and feedback about some of the other exemptions. As Cicely mentioned, the staff has provided guidance, and some of this guidance has been in the context of Regulation D, both CDIs and no action relief. More specifically, we provided guidance with respect to what it entails to have reasonable steps to verify that the accredited investor status has been satisfied for purposes of Rule 506C, the offering exemption that allows for general solicitation. The theme of our guidance is a message that we've been repeating since those rules were put in place. The principles-based approach for verification is flexible, and issuers and their counsels should keep that in mind when one of the enumerated safe harbors in that rule does not capture the particular situation that the company and the investor has. Rather than speaking more about this one no action relief, I want to encourage you to join, and this is a shameless plug, for our CorFin panel this afternoon, where Jeff Byrne, who is the head of our Office of Small Business Policy, is going to provide more detail about that no action relief and some of that guidance that we provided. We also hear about the exemptive framework more generally, both what's working well and improvements that could be made. As part of that, if you're looking for data in this space, I want you to encourage to take a look at the most recent report by the Office of the Advocate for Small Business Capital Formation. They have a wealth of data in that report, including very interesting data that highlights how some of the smallest startups continue to struggle to raise capital in the exempt market. So now that we cover exemptions, I'm going to turn it over to my colleague Luna to talk about the feedback that we've been receiving with respect to public companies.
Great. Thanks so much, Sebastian. Honored to be here today. So continuing on our trend of talking about what we've been hearing from the outside, and this is an item that Commissioner Ueda has said in recent public remarks as well. We've been hearing with respect to the Commission's current rules on the filer categories and associated disclosures are needlessly complex and don't provide sufficient scale disclosure benefits. So I'll give you a couple of examples. If you have a company with a $250 million public float, they would be subject to the same disclosure requirements as a company with a $250 billion public float. So one might ask, is that the right result? Another angle to consider this issue, and which commentators have been raising, is that the Commission has not changed its thresholds for a company to qualify as either a large accelerated filer or accelerated filer since they were established 20 years ago in 2005. So at that time, there was about 18% of all reporting companies had a public float of at least 700 million.
is still the threshold, and therefore qualified as a large accelerated filer. Today, that percentage is doubled to 36. And maybe that's the right percentage, maybe it's not, but it's certainly something we'll be thinking about. I do find one fact interesting, and it's rather preliminary, but I wanted to share it based on our initial review. Registrants with a public float of at least 25 billion make up approximately 80% of the total market public float, but they only account for about 5% of our registrant population currently. So that's a pretty significant number, and we'll be taking a close look at those thresholds. Likewise, and still continuing along the same lines, we continue to hear concerns about how complicated the various overlapping filer statuses have become. And as a result, it's created a big burden to registrants just in terms of figuring out what requirements and accommodations apply to them. And I'll take the smaller reporting company status as an example because that's probably where it's the most acute. Smaller reporting companies, or SRCs, currently comprise about almost 50% of all reporting companies. And as many folks know, they could either be accelerated filers or not. They could also be EGCs or not. And depending on the combination, so SRC and accelerated filer, SRC, EGC, and non-accelerated filer, SRC, EGC, and accelerated filer, SRC alone, I could probably go on. The requirements and accommodations applicable to that company can change. So all of this to say, folks have been really raising concerns around whether this warrants a rethink, and so we'll be giving some thought to whether the current structure is producing the expected benefits or whether the costs and burdens associated with this complicated regulatory regime warrant a rethink and simplification. Another long discussed topic that we're hearing with renewed fervor is around ways the Commission can make the public markets more attractive again. So, in other words, how can the Commission both encourage companies to go public and stay public? So I think, as everyone here knows, emerging growth company status has been a really big success for companies that qualify since Congress created that category in 2012 in the Jobs Act. However, the accommodations are capped at 5 years, and across the board, both on the Hill, from outside parties engaged with us, we're hearing suggestions for ways that the accommodations could be extended, considerations for how to ease the burdens associated with losing EGC status, and things like that. I will give a plug for the CorpFin workshop this afternoon, where we will talk about some steps the division has been taking, including extending the DRS draft registration statement accommodation. But I won't get ahead of our colleagues from that panel. From a Commission standpoint, though, the suggestions we've been hearing, include extending EGC status for a longer period, offering an on-ramp from EGC status, and extending EGC accommodations to more registrants. Another area of focus that Commissioner Ueda recently highlighted is around federal preemption and whether that remains appropriately calibrated. So I'll give you a couple more for instances here. So the question of whether federal law preempts state law, it can be complicated outside of a situation involving a traditional IPO, which, as folks know, the Securities Act preempts state registration requirements for both the primary for securities listed on a national securities exchange, as well as the secondary trading of those securities. On the other hand, if a company files a Form S-1 to register a primary under the Securities Act but does not list the securities on a national securities exchange, the offering is subject to state registration requirements for both the primary and secondary of trading of those securities. And that's even if the company registers the resale of Form S-1 or Form S-3. However, if a shareholder relies on Section 4A1 of the Securities Act, including the Rule 144 Safe Harbor, to resell their shares, then the state registration requirements do not apply. So Commissioner Ueda questioned whether these results make sense. And where a company has expended time and resources to prepare a registration statement that's already subject to review by SEC staff, he's asked whether that transaction should be subject to additional review by the states, especially when such review may not yield additional protections for investors. So we'll be giving his questions some close consideration as well. We've certainly, as others said, are open to hearing thoughts of the public. We look forward to engaging on these and other topics. And with that, I will pass it to Mike.
Can we, you want to for? So I just want to say commend you all for I think a very thoughtful approach to a lot of the issues. And you heard from Chairman Atkins, innovation is a big theme. There was a lot in that statement covering not just CorpFed, but I think the broader SEC. But one of the things that I just want to give a lot of credit to staff on is I think the draft registration statement extension was very for a lot of folks. And I think the issuer community and those who want to be issuers, things like that, PGC extension would be very welcome. You've talked about, crowdsourcing ideas, right? And hearing, it sounds like you have a lot going on, but there's other things that I think would also potentially be interest of the staff. Is this the same sort of thing? It doesn't necessarily need to fit precisely in your sort of cabinet, but we have ideas of sort of rules on the books that could use either further clarity or potentially relief where that may not be functioning as intended. I think to your earlier point of the compensation, I think a lot of people think it's fantastic that the commission is refocusing on this. There's been a lot of movement in the past several years in this space, and there may need to be sort of considerations, recalibration, I think, for how effective information being provided is to investors and obviously balancing the three parts of the SEC. I do think, again, I know you're talking today, I think the late letter was particularly helpful. I think more people have really a lot of thoughts on the creditor investor. It seems to always come up, and then understanding how you can enable people to participate in sort of thriving markets, still protecting them with the rights mandate that you have. But I do think that that's an area where I think this will continue to be a place where a lot of people like to be. I think, in general, there's not a human out here that doesn't capital formation. Right? I think so public area, so registered exempt offering, capital formation comes in all sorts of flavors. But, I think there has been sort of a lot of pent-up excitement for tackling public and things that people have found frustrating. Part of it, very candid, the disclosure. And companies often have the question, we're exerting tremendous effort, and we still don't really understand it. It's actually evil. So if it, it's to disclosure on favors performance, it's just in general, what's the best way for us to sort of convey understanding that, like I said, there's a lot of excitement on sort of previous. And two, do you think the staff, to the extent the commission would be willing, had an appetite to sort of breathe on it?
So I'll take that. I'm going to put executive comp in a separate bucket because the commission's the SEC specifically opened a common box. So I think for anything executive comp related, feel free to engage with us, but also I really do want you to encourage considering something in writing to that comment file because it's a nice way to collect all the feedback there. More generally, Elad, I think you touch in on a topic that deals with engagement and in particularly the line between what the staff can do and what the commission can do. We are happy to meet with anyone to talk about topics that are on either side of that divide. I just want everyone to be aware and understand that what the staff can do, so do staff action, is somewhat limited if the commission has spoken about that topic before. So with respect to that engagement, we've been hearing it on both sides. If it's something that the staff can do that results in consideration and potentially staff guidance, and that is why we have put out so much guidance over the last few months, there are other areas, and those are more the things that Luna and I chatted about, where the commission already spoke about, or there's a rule specifically on the books about it, but we're hearing that the rule doesn't work. We want to hear about that because, as all of you who do rulemaking know, the staff does propose recommendations for the commission to consider. So it's important for us to hear about those ideas as well so that we can actually craft those thoughtful recommendations. So come to us with either one of those topics. But if what you're looking for is staff guidance on something the commission has to do, you're probably going to be disappointed because you're not going to get that from us.
Understood. And I think that's the right answer. I don't think staff should, rewrite the rule, but I do think there's to your sort of a comment, which I want to focus on just for a second. You mentioned how sort of principle-based guidance is particularly helpful. And I think, just echoing what you said is even, I think what you'll discuss this afternoon in terms of the Latham letter, it's important to say that a lot of this is driven by the principles within the rule that staff can provide greater granularity of at least some of the thinking. Because as you said, I understand that you have both sides coming at you. You've had several years in many instances to hear feedback of issues. And I think, this may be a time where you can give a little bit more comfort.
And I think on that topic, just to put just a gloss on it, as you all know, when the commission was crafting the rules for 506C, the statute required the commission, one of the features of that exemption is the fact that the company has to take reasonable steps to verify that the investor is in fact an accredited investor. And when the commission crafted those rules in the proposal, it just proposed a principles-based approach. As part of the comments we received, a lot of the commenters wanted safe harbors. So instead of taking away the principle-based approach, the commission and the final rules added safe harbors for making that determination for reasonable steps to verify. One of the things that we continue to hear is some hesitancy to go back to the principle-based approach. And part of our guidance is to remind people, as you mentioned, Elad, that those rules are flexible and the principle-based approach may be the best approach if you don't fit in one of those safe harbors. But there's many of our rules that have those considerations, and whether it's just a discussion with us just to brainstorm whether you are completely off the reservation or whether you are on point on a particular principle-based approach, we're happy to have those conversations.
Yeah, well, thanks so much. And I want to echo Elad's earlier comments about appreciate tremendous work that you all have been engaged in over the past several months. And as he also highlighted, obviously a tremendous amount of interest and enthusiasm in getting the messages that you're delivering with respect to the transparency that you're willing to have. And one of the questions that I had, and it's on topics I think that maybe Michael and Ted are going to touch on. So with respect to some of the guidance that you all have provided, so certainly like on 13DG, right? Very important, I think. Thank you. So it's a question that's related to that topic specifically, but also some of the other guidance that you all have been putting out, right? So, and understanding how it is operating as intended, how are you sort of monitoring how some of your guidance is landing and your willingness to engage with market participants around concerns or questions they have with regard to the guidance? I know you will use sometimes opportunities and speeches to sort of, answer Q&As that give greater clarity or insight. Can you talk a little bit about how you're dealing with that in real time? Because that's obviously important with regard to how market participants are understanding what's intended by the guidance. So let me stop.
Maybe I'll take a first stab at that. 13DG is a good example of how once we put out guidance, we do keep our ears to the ground to hear how things are going. Just issuing the CDIs is not the end of the game for us. On 13DG, we proactively reached out actually to various different industry groups and investor groups and walked them through the guidance, the purpose of the guidance, and really answered some of the concerns they had in the early days. We also have heard from folks who reached out to us, and I will say there were quite a few phone calls and from all sides, and we took every call. Tiffany Pozo, now M&A chief, were on multiple calls. I handled many calls as well. It could be something formal, such as a group wanting the formal meeting. It could be something as simple as a colleague from somewhere else who called and said, I have clients who want to know, what is this about? We never, of course, want to have information asymmetry among law firms. So whatever we tell them is going to be shared with everybody. But I can say that the staff is very, very active in making sure not only do we reach out, but we respond to every call that we get.
I will just say, I know you're going to talk about it. I want to commend you for, you've heard this a lot, I'm sure, just the red lines that you provide for the questions. It is incredibly helpful for those in the public. And we talked about this earlier, but a consideration I think people would appreciate is, actually doing that for rule text as you guys promulgate rules in the future. Otherwise, many people are going to be relying on associates at law firms to do it. And, understanding potential limitations, I do think that is something that makes all of our lives easier. So I really thank you, Ted, for sort of leading that charge.
Okay, great. So we'll turn it over to Michael, 14A8.
All right, switching topics. So I'll talk about Rule 14A8, which is the shareholder proposal rule, and I'll speak about how the season went from our perspective. As most of you probably know, each year we assemble a task force in the division to analyze and respond to the hundreds of company shareholder proposal no action requests that we get, and this year was no different from that perspective, although it was quite different in a number of ways I'll talk about in a minute. But before I dive into the substance, I know we had a disclaimer at the beginning of the program for all SEC speakers from the commission, but people who have seen me talk on this topic in the past know that I can't, you can't get away from my extra special shareholder proposal disclaimer. So here we go. Our responses to Rule 14A8 requests from companies are informal and non-binding. They represent staff views on the particular basis or bases for exclusion that companies raise in their no action requests. We don't force companies to include proposals in their proxy materials. We don't tell companies that they don't need to include proposals in their proxy materials. Only a court can decide whether a company can exclude a proposal. We also don't make arguments for companies or for proponents. We evaluate the arguments that companies and proponents raise in their submissions and in their supplemental materials. And lastly, when the staff responds to a request from a company, it certainly does not mean that the commission has taken any action with respect to that request. So looking back on this season, I think there were two really main takeaways from our perspective. And that was, number one, the volume of requests that we got this year. And number two is the fact that we put out a staff legal bulletin in the middle of the season. And I'll start with the staff legal bulletin because I think that the issuance of that played a little bit into the numbers that I'll talk about later. So in February, we issued staff legal bulletin 14M. This was a change from our typical practice of issuing staff legal bulletins before a season starts, and it brought with us some challenges that you can probably imagine. We kind of ran a two-pronged approach to putting that out. One of them was actually drafting the staff legal bulletin, and secondly, at the same time, we were deciding and figuring out how the task force was going to kind of switch, pivot and implement a new way of thinking on some of the bases for exclusion that were addressed in that staff legal bulletin. And both of those were challenging for us, but I think that the staff did a tremendous job in getting through the season, responding to every single request that we got this year on time. And the volume was huge, which you'll hear about later on. So on the substance, the new staff legal bulletin 14M was published to address various concerns that the most recent prior staff legal bulletin 14L had, that the constituents had with that staff legal bulletin during the 3 years since we issued that one. 14M rescinded 14L. And I think that the main theme of 14M was case-by-case consideration of proposals, a company-specific approach that we took, and that that the staff laid out, which really reiterated what the commission itself has said with respect to a couple of the bases for exclusion, specifically I-7 and I-5. I-7, just by way of background, is the ordinary business exclusion. It allows companies to exclude proposals that deal with their ordinary business operations. Now, the commission in the past has said that proposals relating to ordinary business but raise significant social policy issues may not be excluded because those proposals are appropriate for shareholder consideration. However, the commission also said that when determinations are made under I-7, they must be made on a case-by-case basis, taking into account the nature of the proposal and the company to which, in the specific circumstances and situation of the company to which it's directed. And I think that 14L, the prior staff legal bulletin, which was rescinded, kind of stepped a little bit away from the case-by-case analysis and focused more on the significance of a particular policy issue. So the way that the staff is now addressing those proposals is to focus again on the specific situation of the company. In other words, what may happen is that when a proposal raises a significant policy issue, it may be significant to one company, but it may not be significant to another. So the responses that companies get with similar proposals may be different depending on the particular circumstances of that company. The second basis for exclusion that was addressed in 14M is I-5, which is the economic relevance exclusion. And that relates to proposals that address operations of a company that account for under 5% of a company's assets, earnings, and gross sales, as long as they are not otherwise significantly related to a company's business. So again, with that second prong of that exclusion, we're looking at significance to a company. So the focus again here is on a particular company and whether the proposal is significant to that particular company. So proposals raising issues of social and ethical significance may be excluded for a particular company, notwithstanding the importance of the issue in the abstract. So the analysis under I-5 and I-7 is similar, but I want to stress that we don't view I-5 and I-7 as being exactly the same thing. There's a different analysis that goes into each of them. They're similar, they're related, but they're not identical. So a proposal that may be excludable under I-5 might not be excludable under I-7, and vice versa. So that's the substance of the new staff legal bulletin. I want to talk quickly about a couple of things that we did and did not do. What we didn't do is just as a reminder, let me step back. 14L rescinded the prior 3 staff legal bulletins that were issued before them. When we rescinded 14L in February, we didn't simply bring back the 3 that 14L had rescinded. But what we did is took a close look at those 3 and think about what was working under them and what wasn't working under them. We brought back the parts that were working, we didn't bring back the parts that weren't working. So the big thing that we did not bring back was what we call the board analysis. We found that the board analyses the companies had provided during prior years were not particularly helpful for us. I mean, they were often cases good, but we often were able to make our decisions based on the information that was outside of the board analysis. We heard from companies that doing board analysis was difficult, was burdensome, so we decided to make a specific point in the new staff legal bulletin that the staff does not require a board analysis when addressing I-5 or I-7. Another thing we did was we knew that a staff legal bulletin coming out in the middle of the season was going to be troublesome for some companies and some proponents in terms of the timing specifically. So we included a set of frequently asked questions right in the bulletin itself to address the questions that we thought were going to come up, such as, can I submit a proposal now that you have put in, now that you've put out a new staff legal bulletin? Can I submit a proposal that I wouldn't have, sent you guys beforehand. And we said, yes, you can. And along with that, we told people we would be more, we'd give good consideration to the new staff legal bulletin in terms of the timeliness of a company's submission to us. So we wouldn't just reject it because it was not within the 80-day limit that's within the rule. Another thing that we did from a process perspective was we tried to limit the number of responses that we put out in the weeks preceding the new staff legal bulletin that addressed I-5 or I-7. We didn't want to have our task force have to learn two ways of thinking, and we didn't want a bunch of reconsideration requests or resubmissions to come back immediately after the new staff legal bulletin was out. So if you were following along, you may have seen that there was a little bit of a lag on I-5 and I-7 responses, and the reason was that we were wanting to address those using the new staff legal bulletin, and we started doing that the day that came out. That being said, we did give companies and companies specifically an opportunity to resubmit the proposal if they thought that the information in the new staff legal bulletin was relevant to their particular analysis. So I think I'll stop there and turn it over to Ted. Looking at the time, I think that's the best course of action right now.
I think that's great. I do think, the ability for companies to come back to you was very helpful. I also think that, the board analysis was a great idea and concept, and it may not have worked as well as people thought it could. So, I think that's sort of the feedback we've heard. But I think many companies were, and I think just the community was appreciative of thoughtfulness of 14M. So,
yeah, I just echo that too. I mean, appreciate the challenge that you faced in putting out the new guide, the new SLB, and such forth. And one of the questions I had, you kind of alluded to. So as you think about, there's a lot of commentary out there about what a potential additional changes might be to the process, to 14A8, and including from Congress, right? You've got a lot of interest congressionally as well. Just curious how you will would go about thinking about potentially additional changes to 14A8 and contemplating more broadly what the broader ecosystem is with respect to proxy voting as well, and the role of proxy advisors. And they play a very significant role. So just when you think about the system more broadly, both the process as well as proxy voting, can you talk a little bit about how that might inform rulemaking? Any potential rulemaking?
I can't speculate on any potential rulemaking. I can say that what we do, and this goes to your earlier question as well, Commissioner Casey, what we do at the end of every season is we have a stakeholders meeting where we gather some of the most prominent proponents and some of the companies and activists and groups that are very active in the space, and we get together and we have a lengthy meeting where we hear concerns from all sides and get feedback. And I'm especially interested in the one we're going to have this year to see how people reacted to 14M. But on a rulemaking, I think if you look back and this rule has been around for ages, and you've seen the commission address it many, many times over the years in many different ways. So if somebody was interested in doing that, I think there's a lot of different ways to approach it, but I can't speculate on what that may be at this time.
Good.
Well, great. I'm going to cover something that I think has become the theme of this event today, which is engagement, but with shareholders. So the staff issued a number of guidance and CDIs on shareholder engagement. I'm going to cover a couple of them, 13DG being one of them, and notice of exempt solicitation. Let's start with 13D and G. We issued guidance in February, providing, frankly, the first staff view on what influencing control means for purposes of a 13G passive investor. And just stepping back a little bit, under the Williams Act and 13D and G, if you own 5% or more of a public company, you have to file a D, which is for folks who have control intent. Or if you're eligible, you file a 13G, which is a far simpler and short form document. Whether someone is actually passive when they file a 13G is something of a discussion for over the years. I sort of recall having this discussion actually at this conference a few years ago, and it's not an easy one to answer, but the staff really does want to engage on this issue because there is a consequence when a 13G filer files and is actually trying to influence the control of the company. Among other things, other shareholders have a right under the federal securities law to know more about that person since they are trying to influence the control of the company and perhaps even change it. So the guidance is actually something where we wanted to update what would happen if you were to move beyond a simple discussion with company about your views and you are actually looking for change. I think it got people's attention. I recall a fair number of articles about large asset managers taking a fresh look at their practices and thinking hard about what they should be doing going forward under the guidance. And I think that's sort of the reaction we were hoping for, which is just take a look at what you're doing, think about the regulatory framework, and think about whether or not what you're doing in those meetings are consistent with the framework that Congress established almost 50, 60 years ago. So a couple of things, and this is part of the how do we, monitor reaction to guidance that we put out. There have been what I would call some overreaction to the guidance, and I'm going to just try to correct some of the misimpressions here. One, the CDI is very clear. It is not meant to stifle shareholders from talking to companies about its views on a particular issue and how it thinks about its voting decisions. That communication chain should continue, and we did not intend for that communication to stop. So if you are engaging with a company and you want to tell them what you're thinking, how you think about an issue, and want to explain it to management, you are free to do so. Nothing's changed on that front. What I think people need to think about is monitoring that conversation. At one point, are you now moving from just expressing your views, and now you're engaged in what I would call almost a quid pro quo negotiation where you are trying to extract changes, perhaps even demanding changes in order to get votes. At that point, I think it's moved beyond what 13G is meant to cover, and the CDI is meant to sort of provide that kind of a framework. But number two, voting policies. We recognize large asset managers and 13G filers have voting policies. We know that they have to provide those. The CDI is not meant to stop people from putting up voting policies. What it is supposed to do is, again, think about what you're going into those meetings about. What are you looking to do? Are you explaining your views, or are you trying to get them to change something in order to get your votes? And the last thing I'll mention is also who calls and who initiates the engagement is something that's relevant in this analysis. If the company is the one surveying its large institutional investors and are calling the asset managers and 13G filers to find out what they're thinking of, it's a little hard to say that the 13G filer is the one pressuring the company. So, we were talking a little bit in the green room a bit about, people not wanting to pick up phone calls. And I don't think that's sort of what we're looking for. You can pick up a phone call from the company. And again, the main thing about this guidance is just to make sure that that conversation is not crossing the line into where you are trying to get something out of the company, change its policy, change its board structure. When you are doing that, you have to be very mindful of whether or not you're truly passive. So I know there's a lot of questions on this front, so I do encourage you to reach out to the M&A office at CorpFin if you have further questions. Maybe I'll pause here and see if the commissioners have thoughts about this.
I think that's exactly right. Look, I think, well, you certainly got a lot of attention. And as you can see from the reactions from some of the asset managers, some immediately didn't know what to do. And I think that's probably a statement to say maybe the way they were thinking about it wasn't always being conveyed correctly. And I think what you saw was asset managers thought about it, and a lot of them are re-engaging. I think from the issuer and asset management side, both want to have that dialogue, to your point. This wasn't meant to end or stifle it. I do think it's important, sort of to the principles-based approach you said, which is you really need to think about control, intent, and change. And not only, what's your intent, but how is it going to be perceived, I think, in some ways, right? So a lot of clarity is beneficial for folks. I don't think issuers don't want to talk to their shareholders, and I think shareholders have fiduciary duty off the case to express their viewpoints to management and others. I think, people in general, and it's not just at the SEC, it's in other agencies as well, have been increasingly focused on this 13D, 13G divide. So it's clearly one of those things that, if you guys were thinking, may require even more sort of principle-based sort of guidance. So I appreciate you offering that, and same with the stakeholder meeting. You'll get a lot of feedback, I think, and these are all inextricably tied. 14A8, 13DG, proxy advisors, the plumbing, all of that. So I think those of us who are maybe not part of the discussions in those engagements would be very interested in sort of hearing the feedback from the staff's perspective of things that, are top of mind. I think there's an insatiable hunger from folks to understand where things are moving. To Michael's point earlier, these rules have been, in some cases, back and forth over time.
Yeah.
Which leads people to believe, markets change, but also hasn't been perfect. So the more I think that, people can have an understanding of what the current staff and commissioners are thinking, be very much valued.
Again, I just reemphasize my earlier point on that as well. And again, appreciate, as Michael had laid out, right? So over the years, we experienced this as well, with different commissions, policy posture changes, and that can be a challenge sometimes for the industry, sometimes welcome, but sometimes a challenge as well. And so also appreciating this as a principal matter. I know you all give a lot of thought to this, but is this concept of sustainability, right? Whether or not you can have rules that ultimately can stand a broader test of time. And I think it's a challenge. And that's not just in this space either, but just with regard to, what the role of the SEC is, its remit. And I think a very principles-based approach helps lend itself to that. So appreciate the work that you guys are doing.
Right. In the interest of time, I'm going to go over notice of exempt solicitation very quickly because I do want to talk about the SIPMA letter that we issued on Friday. The notice of exempt solicitation is guidance, is a topic that also has been discussed over the years. We put out recent guidance about this notice. It's a notice that actually have increased in popularity. I think 5-10 years ago, most of us would have never heard about this, but it is becoming increasingly used for a purpose that the commission did not intend. It is used often by shareholder opponents to communicate in a manner that they probably did not realize was being misused. So we put out some guidance to correct behavior here, and for those in this space, I encourage you to look at it. I do want to talk about the SIPMA letter that we issued on Friday. It pertains to Securities Act Rule 192. It is actually a ABS rule. It's one of the Dodd-Frank rulemakings that the commission completed 2023 November. Compliance is actually starting next week, and actually I think it's a great example of how the staff does continue to work with market participants after the rule is adopted. Our role does not end the day of the open or closed meeting. Open meeting, I guess. We never have a closed meeting about rulemakings, but we monitor and we engage. I credit Kayla Roberts, the acting chief of our Office of Structured Finance, for engaging with SIFMA and other major participants on this. What we learned from this engagement was that the rule was one that folks were really trying to comply with. They really worked diligently to set up the internal compliance systems to comply with this rule, which is designed to basically prevent conflicted transactions in ABS offerings. If you're an underwriter and you're selling an ABS deal, you should not have conflict where you're selling something that the investors would be harmed by. So what the letter really does is provide SIPMA and others with guidance as to how to address some of the ambiguities and the breadth of the rule. And I think it's a good example of where we keep our ears to the ground. We listen to what participants are trying to do. We talk to them. And actually, this one took months, many conversations, many meetings. And at the end of the day, I think we've reached a result that was very workable for folks who have to comply with the rule, but also is consistent with the goal of the commission when it adopted the rule. So I look at it as a model, frankly, of how the staff can work with registrants and other market participants. So I think we have 1 minute left. So
I just want to say thank you. I think I'm going to try to shoehorn one last question just because it's a top of mind, I think, for at least when I was thinking about this as you were talking. There have been, just for clarity for I think the audience, there have obviously been some rules that have been proposed but not finalized. There's also been rules that have been stayed and are going through litigation. Just for clarity of the audience, those rules for purposes of staff enforcement are not either final or take into account as sort of the standing. And if this is a question for the OGC section next time, maybe that's it. But if you guys could, I think, provide a little bit of, at least you were thinking on that would be helpful, I think, for people.
Sure, I can take that. Any rule that has been proposed and not adopted, right, is not subject to any enforcement action. The commission would need to take further action. The same would go for a stayed rule. There would need to be further action before any enforcement could happen. So just to give everyone the peace of mind, no gotchas there.
Thank you.
Well, thank you very much for joining for Cortland senior officers, and a special thanks to former Commissioners Roisman and Casey for joining us this morning. We have just one announcement before we move on to our next panel of the day, but thank you very much.